Ladies and gentlemen, welcome to the first of the Practical Lawyer Knowledge Series. This is a new initiative that we have started. This is the Practical Lawyer magazine, which goes out to tens of thousands of subscribers all over the country. You'll find a copy in your bag. So under this banner, we have started a knowledge series. And today's discussion is on IT, telecom, media, and other sunshine sectors. And the topic of the discussion is reducing the precedent gap for emerging laws. As we all know, these are all sunshine sectors, and a lot of material is not yet available on this in our country. Is it clear? Yeah. And so therefore, do we need to look at foreign jurisdictions to cover this gap in the precedents that we have? We can start first with, there is a little presentation that we have about EBC, the publishers, and we can start that now. that was the presentation about EBC. And I had just a small general knowledge question. How many lawyers does it take to change a light bulb? The answer is 3. One to climb up the ladder, the second one to shake the ladder, and the third one to sue the ladder company. So a very warm welcome to everyone who's here, and this panel discussion that we are having and the new series that we started. Special welcome to Mr. Prasanna, who's our chief guest. Mr. Prasanna is an independent consultant. He is the former group general counsel at Aditya Birla Group and is an independent corporate law counsel. In his career span of close to 4 decades, he has spearheaded the legal departments of leading companies including Alfa Laval, Brook Bond India, Larsen Toubro, and the Aditya Birla Group. He is on the board of the Aditya Birla Group of companies in India and abroad, as well as of another public sector company as an independent director. Mr. Prasanna, please, your keynote address, please.
Can you all hear me? Great. I'll level up with you. I don't like standing there like a pastor giving a sermon. I think today's panel discussion is all about the kind of effect precedents have, and I want to set a precedent by talking about precedents. And also I don't want to set a wrong precedent by talking too long. I shall be brief because it's already past our usual time and I need the panel to get going. My own few observations. Are precedents good, bad? Are they reliable? Are they unreliable? Do people really understand precedent in the right spirit? Do they really distinguish between ratio and an arbiter? Do they mistake one for the other? Do people actually use precedents to formulate a legal strategy without realizing that the very basis of the strategy can be overturned if the precedent is thrown out? There are a lot of pitfalls in using the precedents. Are precedents used only at the very end to influence the mind of the judge when you actually make a closing arguments to help him come to certain conclusion? How do you dislodge a judge from actually following an arbiter as if it's a ratio? Because a Supreme Court has said an arbiter and the lower court feels compelled to follow the arbiter as if it's a ratio. These are the challenges that people actually face. If you are formulating a contract, if you are drafting a plaint, if you are filing a case against somebody, do you actually look at the number of precedents, number of decided cases to formulate the kind of contract that you want or the strategy that you want? I, for one, having done many contracts and many arbitrations, many litigations as general counsel, I'm very nervous about looking at precedents. I keep my eyes completely shut. I say, I'll go by facts. I'll state the facts the way they are, and I'm going to win or lose based upon the facts, because it is only the facts that can be supported by evidence. Any amount of law books will not help you to win the case. I remember I belonged to a very small town, Mysore. I used to practice in Mysore way back, in many, many years back. And my father was a lawyer and my brother was a lawyer. And I remember this very famous conversation between two lawyers, and they came out of the court having argued the matter. One of the clients, who was from the rural area, followed his lawyer and said, I'm very sorry to say, in Kannada I was saying, I'm very sorry to say that the other side did better than you. They had 18 books, you had only 6 books. So the question is it a matter of creating an impression? Or is it simply confusing and browbeating the judge? Or is it downloading so much of information on the judge is completely confused? There are people who actually use precedents for various other reasons. One of the Australian judges actually say he hates precedents. He says following precedents is a sheep mentality. It actually takes away innovation. They say judicial realism is all about how you are going to actually decide a particular question of law the way it is applied to the facts. There is judicial activism. A precedent born out of judicial activism, is it reliable? It's some kind of a social upheaval or a political movement that has given rise to that precedent. Is it really applicable to another situation that happens? So any precedent which is based upon judicial activism, is it really good? Is it reliable? Jury is still out. So at the end of the day, you have to decide. You have to set a precedent for yourself. Are you going to be a lawyer who is going to really look into precedent and rely on them to win the case? Or you're going to simply use the precedent as the final push, the final thrust to get the point across to the judge? Thank you. Thank you very much.
Thank you, Mr. Prasanna, for giving us that perspective on precedents. And I do hope they're still valuable. We should start our panel discussion now. And I would like to please welcome Mr. Rahul Mathan. He is the co-founder of Trilegal. He will be chairing and moderating the discussion, please. Rahul is the head of the technology practice of the firm. He has an extensive experience of over 2 decades. He focuses on technology, information property, strategy advice, and disputes relating to technology companies. As a recognized technology law expert, he is frequently called upon by national institutes like ISRO, NIAS, IIS, IIM Bangalore, and leading forums like NASSCOM, CII, MATE, etc. He has drafted the world's first open source technology distribution license. He was also showing me some of the stuff that is on his phone. It's very fascinating, absolutely. Thank you, Rahul. I would now like to invite Mr. Rajiv Nair. He is the Director and Country Counsel for Hewlett-Packard. As Country Counsel of HP, Rajiv advises HP's sales entity and global delivery centers in India on various legal issues relating to commercial contracts, litigation, and corporate matters. Prior to joining HP, Rajiv has spearheaded the legal and compliance departments of HSBC and ING, and was also part of the legal team at Unilever. Thank you, Rajiv. I would now like to invite Mr. Shreyas Jayasimha to please join us on the dais. Shreyas is founder and managing partner of Arna Law. He is an advocate, arbitrator, and mediator at Arna Law. He is experienced in handling domestic and international dispute across various industrial sectors. Welcome. I'd like to now invite Mr. Samuel Money. Mr. Money is the founding partner at MCM Law. He has extensive experience in running complex, high-stakes matters and specializes in advising clients on commercial and outsourcing transactions, privacy and data protection matters, dispute resolution, and deal structuring. Prior to founding the firm, Samuel was the global head of legal for Infosys Limited and all of its subsidiaries. I also want to invite Sudeep Malik. He's the managing editor of ITCC. This is the new journal that is going to be launched today. And Sudeep is also associate editor at SCC, and I think he has his job cut out today, defending ITCC and how we would like to find precedents and use them in this new sunshine sector. So it's over to you.
Okay, we're a bit cramped on stage, so we're good friends, but not really this good friends. So, you know, when we have these kinds of panel discussions, the instinct is to have presentations, people stand up and talk, and we decided perhaps we wouldn't do that this time. And instead what we've agreed over one phone call where I sort of proposed this and no one objected, to argue on two sides of a proposal, a proposition. Just like, you know, when we were in school, we debated a proposition. And the proposition for debate today is the use of international precedents in IT, media, and telecom cases is crucial for the resolution of Indian disputes in these sectors. So there are some people who will speak for and some people who will speak against the proposal. And it will be up to you to decide who is speaking for and against in the first instance, because that's a bit of a mystery even to me, and I think some of them are going to come to this conclusion as we go along. But hopefully at the end we can take a vote as to whether you think international precedents are crucial for the resolution of Indian disputes in IT, telecom, and media. But before we start, can I, with a show of hands, ask you to say at this point in time if you think that international decisions in the TMT sector are crucial for us in India resolving disputes in those very sectors. All of those who think that it is crucial, please raise your hands.
I think
Crucial is a big word. I mean, come on, guys, we're lawyers. That's the reason why. But if anyone on the panel tries to get away with a Weasley argument like that, I'm not going to allow it. They've got to have really solid arguments. Right? And the great thing is we've got a wonderful panel because, sorry?
It's crucial at this time.
It is crucial. Okay. I'll allow that. So we've got a panel that actually represents a wide range of different views. So hopefully all of that will come into play. We've got a litigator who will represent the actual view of taking this down into the trenches and using it. We've got a representative from big multinational corporations who have their own interests in this context. We have an advisor who represents a lot of these big multinational clients, but probably sees both sides of it. And we've got a representative of the industry that actually makes these precedents available and accessible to all of you, who would very much like to continue to believe that this is relevant. So if I can just ask everyone to quickly make a 1 or 2 minute statement as to what you think as opening remarks. We'll then get into a little more of a discussion. Yes?
What I've had to say, I thought would be the unpopular position and controversial. But Prasanna's ventilated it to some extent. But I speak as a trial lawyer, as many of us who would have met in the corridors of court, as well as a person who argued before the IT secretaries and the IT Act. And my view is to speak against the proposition, because I feel that is the only realistic and honest position to take today. I will elaborate in further comments.
Rajiv?
Yeah, thanks. Shreyas made a very strong word, that honest. Okay, I think we'll have a
Want to be
good,
provocative.
good debate on that one. But I'd like to talk from two perspectives. One, as a lawyer myself, and secondly, as representing an industry, which is the IT/ITES industry. And from the perspective of being a lawyer, as well as from this industry, I think I'm for precedents. Okay, and I think how crucial is it at this stage, at this point in time, is something which we could actually debate further. But then they are really important, and I think precedents fill in that gaps which exist at the moment in those areas of law in the country. We're calling this sunshine from the perspective of the industry sector. I think it's also sunshine from the perspective of where the law stands on this industry now. So I'm for it.
Okay. Sam?
So actually, I guess my perspective depends on where I'm at a particular point in time, right? So if I'm looking for a precedent, yes, I want a precedent. If I find the precedent I find is not really nice, then I wish precedents didn't have that same sort of value. And really, and it's interesting because we're talking about international precedents, right? So there is a very clear hierarchy in India about how precedents will be viewed. If the Supreme Court has said something, then I don't think the rest of us really have you have to go back to the Supreme Court or you have to make some really good arguments for it. That said, a litigator friend of mine says good facts make for good cases, bad facts make for bad cases. So really we're back to Prasanna's point about the facts being the paramount thing. I will also sort of, okay, maybe not preview, but we view, we're all trained as common law lawyers, and so there is this whole value to precedents that we ascribe. And it's actually interesting because I was talking to a client who comes from a civil law jurisdiction, and she was just like, this stuff doesn't exist, right? We don't think this way. We don't view the law this way. So maybe all of this is essentially a common law construct in some ways. And the question is really whether in a sunshine sector like information technology, there is a common law at all. Whether our traditional views of the common law are still valid. And we'll talk about it later. So it's basically against. Okay.
So Sudeep, you want to round it off?
Well, I have little choice as to which side I can propose. Even before ITCC, my life is SCC. But I do believe in precedents and the common law system. And I do believe that I am a positivist. You've had a lot of realists here this evening. Mr. Prasanna did put the cat amongst the pigeons by saying it's all realist. The lawyers can do what they want, can twist the law as they feel like, and the judges can also twist things as they feel like. I'm not persuaded of that view because I am a positivist, and I believe that the law is as laid down by the legislature, and then that must be explained and developed by judges. And they do it in a good spirit, in a spirit of sincerity most of the time. So I didn't think I would have to defend the doctrine of precedent itself, but I guess that's also on the floor today, makes it very interesting. And then coming to the specific topic, so I would be defending precedent itself, and then I would be arguing how our worlds, our consciousness, global consciousness is converging. So I agree with Samuel that there is no common law, but that's why it leaves us a whole new opportunity to create a global common law. So that's the position that I'll be taking.